So, happy Thanksgiving to everybody. Hopefully you were able to get away and enjoy time with your friends and family. But as we see is the case, a lot of the times, sometimes things happen just before a holiday weekend. We saw some of that, of course, when it comes to the state's gun and magazine ban. But let's go ahead and get on into it with the latest out of the courts when it comes to where we're at in the ongoing cases against the state's gun ban. You may have seen Law Weapons. They actually took time with Washington Gun Law over the holiday weekend to talk about their AR-15 bolt action conversion, which they say will be able to convert the bolt action in your AR-15 from semi-automatic to bolt action. So they've got some of those informational pieces on their website, lawweapons.org, and you can find out more information about that. But ultimately, it's about installing a new bolt into an AR-15, therefore making it no longer a defined assault weapon. And they go through and say that this kind of comports to Illinois law. I'm not a lawyer, so I'm not going to be able to give you any kind of advice. We are hoping to talk with Robert Beavis at some point this week to elaborate a bit more on that bolt that he's created to ultimately allow for you to change it out and take the gas-powered operated semi-automatic action out of your AR-15, replace it with a bolt-action bolt. Therefore, he says it renders it as a bolt-action rifle rather than a semi-automatic rifle, thereby saying it's not a semi-automatic rifle and no longer an assault weapon. I'm not sure what that means for, say, the various components of an AR-15 that would be considered by Illinois State Police as assault weapon attachments. But I guess that's a conversation for another day. We will hope to connect with Robert Beavis to elaborate a bit more on that. But one other thing that's kind of fascinating here when looking at Robert Beavis's case in particular, you've got, of course, consolidated cases that are in front of the Seventh Circuit Court of Appeals, where you have a bunch of the plaintiffs now saying that they want to go to enbanc. So Robert Beavis's case in Naperville, which included the state of Illinois eventually, also included a case out of Chicago. And those were lumped in from the Northern District with the Southern District cases. And then you have the Seventh Circuit Court of Appeals, three-judge panel, say that the lower court's Southern District's preliminary injunctions vacated and the state has a likelihood of winning on the merits. So they essentially sided with the state. Well, all of the plaintiffs have now said that they are indeed going to be asking for that en banc review. So looking at the Seventh Circuit, you've got paper copies that were filed just before Thanksgiving, a motion filed by Robert Beavis in particular and Gun Rights Association, the National Association of Gun Rights, for an injunction pending review. Now, this is interesting. So the injunction pending review, if we take a look at that filing and follow along with me here, you've got the filing and the outline and the statement of facts and so on, but just the table of contents, right? The arguments they lay out, the Heller-Bruin framework of the Second Amendment analysis. Step 1, plain text covers plaintiff's conduct. Step 2, because the banned arms are in common use, the state cannot meet its burden. And then summary, the act is unconstitutional. They said that the panel, the three-judge panel, made several errors. The state's handgun ban is clearly unconstitutional. The panel holding the firearm is not in arms conflicts with Heller. The panel misconstrued Heller's useful for military service passage. And the panel's holding conflicts with Staples, a different ruling. The court failed to apply Bruin to the magazine ban, and the panel's majority's continued reliance on Friedman cannot be reconciled with the Bruin case or other precedent. In summary, they say the panel's analysis was faulty and the plaintiffs should prevail on the merits. Goes on to say that plaintiffs are suffering irreparable harm and an injunction would not harm the public interest. So those are some of the overview arguments that being made by Beavis's attorneys here. But when you look at, of course, the Seventh Circuit case, they have those paper copies filed. And you've got Caleb Barnett there. You've got the National Shooting Sports Foundation and a bunch of Dane Heller, the Illinois State Rifle Association, Second Amendment Foundation, and others in that case. Even the Federal Firearms Licensees of Illinois, Gun Save Life, and more. All of them lumping together saying that they want en banc hearing, not just this three-judge panel. But when you look at the standalone Beavis case on the docket, again, there's a Seventh Circuit case with all the consolidated plaintiffs. But then there's also the standalone Beavis case in the Seventh Circuit. And Beavis did file, papers for rehearing enbanc. But you also have an order that was placed just before Thanksgiving on the 22nd saying that plaintiff's appellant's motion for an injunction pending the disposition of the petition for rehearing enbanc and the filing of a disposition of any follow-on petition for writ of certiorari for the Supreme Court of the United States is denied. So, again, they're trying to get some kind of injunction in place while this case plays out, and the three-judge panel said, nope, that's denied. So, again, just a little bit of a status update when it comes to the latest in gun ban litigation. Something else, too, just to highlight here, you've got the latest in the Southern Districts where December 12th is going to be that oral argument for Judge Stephen McGlynn to hear from the state defending against the federal firearms licensees of Illinois, trying to put a hold on the gun ban registry. We'll touch more on the gun ban registry here in a moment, but that's still on the calendar, right? December 12th. Put that on your calendar. We'll be covering that. It's going to be a virtual hearing. You might be able to tune in by phone, but we will be live tweeting that out at least as much as we can via brief notes, and we'll review it the following morning. But December 12th, that's coming up rapidly. And Judge Stephen McGlynn, if you recall, before the Thanksgiving holiday, during a status hearing, said that he hopes to get a conclusion to this, at least a judgment on a preliminary injunction, before the end of the year, because you got January 1st being that deadline. So we'll watch that closely. But some other updates when it comes to litigation against the state's gun and magazine ban. You've got, of course, all of the disparate cases from the Southern District to the Northern District consolidated in the Seventh Circuit. When is this thing ultimately going to get to the U.S. Supreme Court? That's a good question. We have the Calkins case that's docketed at the U.S. Supreme Court, and we'll have to talk a little bit more about that case in particular with some headlines out of the Chicago Tribune about a political action committee that State Senator, Senate President Don Harmon has that is at play in that complaint of conflict of interest. So we'll have to unpack that in a future video here. But totally separate law that is being challenged in the courts, and that's the firearms industry liability law. And if you recall, that was passed over this past spring, signed by the governor in the summer, and it allows for private right of action against the gun industry for making a less safe environment, allegedly, to allegedly advertising to children, or allegedly advertising for paramilitary activities the state deems illegal. So you've got some First Amendment questions in there. You've got 14th Amendment questions in there, and that law was obviously challenged by various plaintiffs. But just before the holiday, you had a response to a motion to dismiss. So the state came in and wanted to dismiss this claim against the law. So the response in opposition to that motion filed by the plaintiffs. Then you had a motion for an extension from the state looking for an extension to reply, and also looking to file an over-length reply. So Attorney General Kwame Raoul filed that motion just before the Thanksgiving holiday. And then on the 22nd, the court ordered in part, and I'll just read here from the docket, motion for leave to file a reply. The court finds that exceptional circumstances justify a reply, but that defendants should do so succinctly. Accordingly, defendants may file a reply to plaintiff's response to the motion to dismiss, limited to 5 pages in length, on or by December 11th, signed by Judge Stacey Yandel. So you've got the latest there when it comes to the status of various cases against the states for various laws that they've filed and signed and enacted when it comes to impacting the Second Amendment here in the state of Illinois. So again, just a brief little overview of some of the action that happened before the holiday weekend. Of course, there's going to be a lot of other things that pop off, and we'll be here each and every weekday morning to keep you updated on the latest. All right, so be sure to like, subscribe. Again, thanks to everybody who has subscribed. It's unbelievable to see more than 10,000 subscribers here on YouTube. It's blowing me away. You guys are definitely making this worth it, getting up every morning and giving you guys the latest. Stay tuned. We'll talk about the gun registry, and some new numbers from Illinois State Police. So that's coming up here in just moments. I'm Bishop. It is Bishop on Air.